Some technological difficulties there, sorry about that. My name is Natalie Levman, and I work with Jillian and Carol at the Department of Justice, and I'm very, very pleased to be here to introduce and moderate our next panel on the sexual assault trial, in particular evidentiary provisions, testimonial aids, and expert witnesses. So just in the interest of ensuring that most of the time is spent hearing our panelists, I'm just going to very, very briefly go over who I have next to me. First, I have Professor Karen Busby. She is a professor at the Faculty of Law of the University of Manitoba. And next to Professor Busby, I have Jill Witkin, who is counsel with the Crown Law Office. And she's also chair of Ontario's Sexual Violence Advisory Group. And next to Jill, I have Michael Spratt, who is a defense counsel with a boutique criminal law firm, Abergel, Goldstein and Partners. And next to Michael, I have Mr. David Butt, who you heard earlier today. He's a barrister with Camden Lane Law Chambers and has experience representing victims in criminal law matters. And of course, you've already been introduced to the Honorable Judge Corbett at the end of the table. And so what I propose to do is ask our panelists a few questions, and then we'll have time for questions from the audience. So to start with you, Professor Busby, based on your work in relation to sexual assault generally and trials in particular, could you provide a brief summary of relevant evidentiary rules, in particular the rape shield provisions and the third-party records regime in the criminal code, and also identify some of the more significant academic critiques of these rules in merely 7 minutes?
Thank you very much. It's a big task, but I figured out some ways to try to do it. I first want to start, though, by acknowledging that we're on unceded Algonquin territory, and I want to thank Elder Roberta Della Pica for the ceremony she performed in advance of today's proceedings, and for the ceremony, the song that she sang for us this morning to ensure that we get off in a good way. I really appreciate that and want to thank her for that. So let me start. Let me start by asserting that Canada has good sexual assault laws on the books. And this is the most important takeaway from my presentation this afternoon. Our laws are based on the notion that a defendant's right to full answer in defense is not absolute and it's not unfettered. The defendant's right to full answer in defense exists together with other valid social interests, including that wrongful behavior should be denounced, and with other constitutional rights, in particular the right to equality and the right to privacy. So if you take away nothing else from what I have to say today, I want you to take that away. The defendant's right to full answer in defense is not absolute and it's not unfettered. And something we heard repeatedly today is that the laws on the ground are just not working well. Feminists work hard in the 80s and in the 90s and in the 2000s to ensure that Canada has really strong sexual assault laws, but something is going wrong. And what is it that is going wrong? So I'm going to talk about two things in the brief time that I have. I'm going to talk about sexual history applications, and I'm going to talk about third-party records. Carol Morency reminded us this morning that the criminal code has both a categorical exclusion of any evidence of a complainant's sexual activity when that evidence is being used for the purpose of invoking either that women who have had sex are less credible or are more likely to consent. The criminal code also creates a presumption of inadmissibility against the use of sexual history evidence in other situations unless the evidence is specific, relevant to an issue at trial, and of significant probative value that's not substantially outweighed by prejudicial effects. So there are categorical exclusions and there is a presumption of inadmissibility. The other thing, of course, is that an application has to be made in court before sexual history evidence can be used in any sexual assault case. So there are a couple of problems that I want to point out with on the ground with how this law is applied. Research. Oh, and I should mention to you, Janine Benedette and I put together a list of recent English language research on Canadian sexual assault law, and it's in your material. And the references that I'm going to point to in my 7 minutes are all included in the sheet. The citations are there. You can go away and you can find them. So researchers, including Ruthie Lazar, Jennifer Cochin, and me, have reviewed sexual assault case law, and it shows that these reviews consistently demonstrate that at least some defense counsel, and it's hard to make claims about how many because these aren't prevalent studies, at least some defense counsel question complainants on the stand about their sexual history without first making a Section 276 application and without any objection being raised by either the Crown or by the court. I was on a panel last week with defense counsel in Crown, and I stated this, that these applications are not made, the evidence goes in all the time. And they both shrugged their shoulders and freely acknowledged that it occurs often in Canadian courts. And they weakly tried to justify it as something that was expedient, that the applications take too much time, they're too complicated, they know the evidence is going to go in, so they just want to move ahead, and they start the questioning on sexual history evidence without an application being made, without an objection from the Crown, and without an objection from the judge. So that's a serious problem. Research also shows, and here I'm referring to work of Elaine Craig and Lise Gotel, that some judges still must understand what evidence is excluded by Section 276. For example, judges merge together the categorical exclusions of evidence with the kinds of evidence that's presumptively inadmissible, and all they do is look at the categorical exclusions. Elaine Craig talks about how judges rely on a so-called pattern of consenting in circumstances where the case law is clear that the evidence should not be admitted because it doesn't meet the test of being so unusual or strikingly similar so that that kind of evidence can be admitted. So as I've said, the use of sexual history evidence remains a serious problem in sexual assault cases. And so I have 4 suggestions on how to remedy this problem. 1 is better Crown training. 2 is to keep the pressure on judges to insist that Section 276 applications are being made. 3 is to really remember that there is no right to a discriminatory defense. And David Tanovich and Elaine Craig both convincingly argue in recent articles that it's unethical for defense counsel to rely on discriminatory stereotypes in the defenses that they present. And so there was a question this morning from someone from Vancouver asking about what to do about this, and I think there's a range of strategies that we can use to pressure defense counsel not to rely on discriminatory stereotypes in the questioning that they do. And my final point would be that if we can't rely on the Crown, if we can't rely on the defense, and if we can't rely on the court, then maybe what we need to do is ensure that complainants are represented by counsel to ensure that sexual history evidence is not going in inappropriately without application and not being used inappropriately. The other thing I just want to briefly discuss, because I have 1 minute left, is that is third-party records. So everybody here knows that no record relating to a complainant or a witness shall be produced to an accused in any sexual violence proceeding unless the process used in the criminal, set out in the criminal code is used. Now, the first problem with third-party records cases is that no research has been done in the last decade on how these records are being used. I'm not aware of any academic studies in the last decade, and this is a very significant research gap. But I informally surveyed, and I have to stress informally surveyed, frontline service providers, Crowns, and complainants councils, and I asked the question, are these regimes working, and can the regimes be improved? And what I was told is that constant vigilance is key, and that there are 3 things that are needed. First of all, provinces that don't have programs to provide counsel need to set up programs. Complainants are entitled to have a counsel for third-party records applications, and most complainants obviously can't afford counsel, so provinces need to put these programs in place. Secondly, reasons for decision on records applications are almost never transcribed and released as formal formal reasons for a decision, and that makes it very difficult to do research in this area. So we need to find a way to ensure that these cases are transcribed and published. And finally, the final problem that was identified is if defendants do come into possession of the records, and they frequently do come into possession either because they're child welfare records and that they are entitled to have access to as a family member, or in breach of a deemed undertaking rule in cases where there are parallel civil proceedings, or through inappropriate Crown disclosure. There is a Supreme Court of Canada case that says they can be used if the defendant has them. And this loophole, in my view, needs to be closed. So I'll stop there. Thank you very much.
Thank you for that very concise and informative overview of some complex provisions in the code. Next, I'd like to turn to our Crown Attorney on the panel, Jill Witkin, and I have a question for you. As an experienced prosecutor and given your role as chair of the Sexual Violence Advisory Group, could you reflect on the evidentiary challenges that Crown prosecutors face in sexual assault trials? And after that, if you could provide us with just some brief reflections on what you feel are the key takeaways from Dr. Haskell's excellent presentation over lunch. Thank you.
I'm to do this quickly. Everybody can hear me? Thank you. Generally speaking, in sexual assault trials, the main witness is going to be the complainant. We sometimes have corroboration, but often we don't. And in most sexual assault trials, credibility is going to be the big issue for the trier of fact to decide. So really the challenges that we face as prosecutors is how do we effectively get the evidence of the complainant before the court? How can we make sure that the complainant is as comfortable as possible in giving her evidence, and how can we make sure that the court really understands what her evidence means? We have things like testimonial aids, the threshold of when you can use a testimonial aid, which is either a screen, a one-way screen in the courtroom, or closed circuit television where the complainant can testify outside of the courtroom so that he or she doesn't have to be in the same room as the accused. The standard for using that for adults has been lowered recently as a result of the Canadian Victim Bill of Rights. I think Crowns are challenged in using it, number one, just because there aren't very many closed-circuit facilities, for instance, in each courthouse, and some of them don't work very well, but also because what we hear is that Crowns feel that they will be given a hard time by the court if they ask for it, because it is time-consuming, and I think the expectation is that complainants should be able to testify in the courtroom. So we need to do more work in that area and really push the envelope in the same way that we did with children when the application was discretionary many years ago. It was called more and more. There was a lot of social science research that showed how children could give better evidence if they were not in the same room as the accused, and eventually those laws changed, and now it's presumptively mandatory for children and adults with physical or mental disability. So that's one area. The preliminary hearing for a sexual assault complainant is difficult. Most, I would say almost all preliminary hearings in sexual assault cases are really for the purpose of cross-examining the complainant at length. They're not to argue committal. There's very, very few cases where committal is actually argued in a sex assault case. There's very few preliminary hearings where the preliminary hearing is waived, and understandably the defense counsel is going to want to engage in a full cross-examination, try to essentially generate a second statement because there's already a police statement of the victim. This is the second statement upon which there can be inconsistencies found at the trial level. So now by trial there's two former statements. And a lot of these inconsistencies that are ultimately identified, if they're material, then of course they're important, but if they're on peripheral issues, sometimes this can be very difficult for the Crown to get over. And the preliminary hearing on a more social level for complainants, there's research that's shown it's so difficult for complainants to testify even once talking about this type of evidence that testifying twice is really, really difficult for them. And so I think we struggle with sometimes losing, we struggle with, my mic on? We struggle with complainants losing confidence in the system after being questioned in very intrusive ways. As Crown attorneys, we do obviously want to object whenever we can. Perfect example, just noted by Professor Busby, is 276 applications. While they're supposed to be brought in advance, they aren't always brought in advance. And the problem that the Crown has is if they are brought during the preliminary hearing or the trial, we have a choice. Well, we want to be able to marshal our best argument to the court to ensure that the court understands why the evidence proposed should not be admitted. However, is the answer an adjournment? Possibly not, because that's not going to advance the case. It's not going to help the victim to have an adjournment and not be able to testify. So sometimes the Crown is going to have to make that argument on the fly without necessarily having a lot of preparation. I only have a minute left, but I want to talk about Dr. Haskell's evidence, because we talked a lot about neurobiology of trauma and how important it is for police and prosecutors to be educated. One of the challenges we have as prosecutors, and let's assume we are educated because we all see the benefits of understanding how a behavior of a complainant of sexual assault, a victim, can be affected by the brain, and also how her ability to encode memories and describe an assault might be affected. We may be able to deal with that, but then when we're calling this evidence in court, how is it that we can get that evidence before the court? Sometimes a victim is able to describe why she may have acted in a certain way, if she was numb or if she dissociated, but often she may not be able to. And as a Crown attorney, we can't give evidence, so really we have to move in a direction where we can start to call this type of expert evidence in court. It hasn't been done a lot in Ontario. I don't think it's been done a lot in Canada. I would say that this is evidence of human behavior, similar to the type of evidence we called in explaining delayed disclosure or battered spouse syndrome. I would say that this evidence certainly should be called in cases where it's appropriate, not to prove that that particular victim was assaulted. That would be going to the ultimate issue, and that's not allowed, but simply to neutralize her credibility, because the defense may be arguing, or the trier of fact on their own, having certain assumptions about how life works. They may view her credibility in a negative way. And this type of evidence is really important because it will neutralize her credibility, not show that it's more likely or not that the offense occurred, but simply to bring her credibility from -1 to 0, so that everybody's on a playing field. It's really to offer an alternative explanation to what might appear to be counterintuitive behavior. And I certainly think that the type of training that we get from the neurobiology of trauma is so important all across the spectrum, from police to victim service workers to Crown attorneys, but also to the triers of fact who make the decisions at the end of the day, because they really are the ones that are assessing credibility. And we have to have a way to be able to provide explanations as to why a victim may have acted in a certain way, or why their memory may not be as you might expect from another victim. So I think that's more than my 5 minutes.
Thank you, in particular, for making the links between Dr. Haskell's presentation and your role in the trial process. And now I'd like to turn to Mr. Spratt. Given your extensive experience as defense counsel, what are the greatest challenges for you, defense counsel generally, in relation to evidentiary issues in sexual assault cases? And given that, hopefully you'll have time for my second question, which is about the issue of ethical cross-examination that's come up already today a number of times, and I'm sure the audience would like to hear your views on what such an ethical cross-examination would look like. Thank you.
So I'll first start by talking about some of the challenges that we face. And the first one I'm going to talk about isn't specific necessarily to sexual assault cases, but is something that sort of permeates the criminal justice system. And that is that there can often be overt or unconscious myths or stereotypes that operate against an accused person, specifically as they relate to racialization or indigenous status of an accused individual. And of course, those could be perceived or actual. They can be systemic or overt. But if we look at a judge alone trial, and if we I'll look at the court that I practice in Ottawa, until very recently, there was not one judge in the Ontario Court of Justice who was a visible minority, and that same holds true in the Superior Court of Justice. And that's reflected to one degree or another, to some extent or another, across the justice system across Canada. And so we have a problem, especially if you're a racialized accused person. There's a perception that there could be inequality and bias and prejudice in the very actors who are judging your guilt or innocence. The same problem is equally present in the jury system. Our juries are not reflective of the community, and Indigenous members of the community and racialized members of the community are not only underrepresented on our juries, but systematically excluded from our juries. In the last very serious jury trial I did, out of the whole jury pool, there were 3 visible minorities. And each one of those visible minorities was challenged preemptorily by the Crown. The Crown exercised their right to excuse a juror, and they don't have to give a reason. Each of those visible minorities was excluded and challenged by the Crown. And this left an all-white jury to judge my client, who was African American, who had committed, allegedly, an offense against a white woman. And so that's not a good place to start from the perspective of an accused person, when the people judging you in the justice system isn't reflective of you. So that's sort of a more general comment, but moving into sort of a specific thing that I've seen quite a lot, and I've seen Crowns make submissions on this point in sexual assault trials, the idea that no complainant would subject themselves to a process of launching or complaining to the police about a sexual assault, of airing personal details, of subjecting themselves to cross-examination, that no complainant would go through that process if it wasn't true. And I mean, we've seen this after the Ghomeshi trial with some hashtags about believing complainants, and certainly out of court, that might be a very productive and pro-social view and a supportive view. But in court, it's more difficult. And we sometimes see that in submissions that Crown attorneys make and comments that some judges have made on occasion about, well, what is the motive here for a complainant to fabricate a story? Because the complainant says it happened, so it either happened or it didn't happen, so she's either fabricating or telling the truth, and what would her motive be to fabricate? That sort of way of thinking is antithetical to our criminal justice system, where the Crown bears the onus, and there's no burden of proof on an accused person to show why someone would be lying or fabricating. So that sort of idea is a subtle and somewhat insidious reversal of the burden of proof that can operate as a barrier to effective justice. And I think that as we have a more nuanced discussion in larger society about being supportive and dealing with these very serious allegations appropriately out of court, there needs to be a lot of work put into the process in court to make sure that some of the fundamental freedoms that are really there to prevent wrongful convictions don't operate. I think I'll move quickly, because I don't have a ton of time, into ethical and effective cross-examinations. I think what defense lawyers should know, and certainly any defense lawyers that I've dealt with, I try to make this clear, and I think that it is widely spread belief amongst defense lawyers, is that there's no benefit to a cross-examination that relies on twin myths or that attacks the character of a complainant. Not in front of a jury, and I think more and more not in front of our judiciary. I don't think that advances the issue at all. Having said that, there needs to be a cross-examination of the complainant. I heard a panelist talking earlier today about, complainants quite often go and talk to the accused after the allegation. And defense counsel, can bring that up to try to discredit a complainant or to undermine her story. we need to be careful in how we look at sort of the cross-examination, because defense counsel don't bring up the fact of contact. The defense counsel will bring up the fact that contact was made and maybe denied after the fact. So it's not the fact that a complainant acted in a certain way, but that those actions maybe were presented or not presented or hidden from the trier of fact. It's issues like that that are important. And moving on to sort of the talk about preliminary inquiries, which I think is really important. I hope we have more time to talk about it, because as we deal with court delays and charges being stayed for delays, the preliminary inquiry is going to be something that in the justice system we're going to be talking about a lot more. Preliminary inquiries, at least how I conduct them in sexual assault cases, I've never confronted a complainant at a preliminary inquiry with inconsistencies. I've never done a hard cross-examination. They've all been exploratory cross-examinations, and mostly exploratory cross-examinations to see if there are any other applications that need to be brought with respect to third-party records or prior sexual contact or conduct. If the preliminary inquiry is eliminated for sexual assault cases, many of those issues won't be discovered until mid-trial, and so there won't be an ability to give advance notice to make sure that the complainant does have counsel present. And quite often, if those applications are brought in the middle of a trial in front of a jury, it might lead to an adjournment or a mistrial that might have other unintended consequences. So when we're looking at broad and systemic changes to the criminal justice system, I would encourage everyone to not look at the worst case scenarios or some of the bad examples that we have seen, and can't deny that there are those bad examples, but look at what ethical and efficient cross-examinations look like, and also look at perhaps some of the unattended consequences that may arise by increasing procedural protections or by sort of diluting other procedural protections. Thank you.
Thank you so much for that, addressing what I know are issues everyone is interested in today. Now I'd like to turn to Mr. Butt. Mr. Butt, given your experience representing victims of sexual assault in criminal trials, could you tell us how you would describe the role of counsel for the victim? And also, could you describe what, in your view, are the biggest legal challenges facing victims in sexual assault trials?
Thanks for those questions. And I do represent a large number of complainants in sexual assault cases as part of my broader criminal practice. And it's something that has evolved over time. Just to give you an example, we heard earlier about how the rape shield legislation was struck down and then reintroduced in the early 1990s. So now a court application, as of the early 1990s, a court application is required before any evidence of a complainant's prior sexual history can be adduced in a trial. But when that legislation was passed in 1992, I think it was, the only people pursuant to the legislation who can participate in whether a complainant's sexual history is part of the trial fabric are the Crown and the defense. The one person to whom it matters the most, pursuant to that legislation, has no standing to participate. So that tells you that as recently as 1992, the notion of affording complainants a real voice in proceedings that affect them dramatically wasn't even on the radar. Later in the 1990s, when the third-party record regime was introduced, complainants were given access to counsel. Operationally, it still doesn't happen in a lot of provinces. So we're in the very early evolutionary stages of just figuring out how to fairly give complainants a real voice in the criminal justice processes that affect them so dramatically. So given that early evolutionary stage, I'm not going to pretend to talk comprehensively about the role that complainants' counsel can play. Joe Witkin and Daniel Brown, a defense lawyer, are writing a marvelous book on the prosecution and defense of sexual offenses, and they've been kind enough to ask me to write the chapter on representing complainants. So if you want the full meal deal, buy Jill's book. I'm just going to touch on a couple of things. And in what I'm going to touch on, I want to acknowledge my real debt to the work that people like Laurie Haskell are doing. Because I want you to imagine the situation of a complainant in a criminal investigative and prosecutorial process. First of all, we've already heard lots about how intimidating it is to just come forward in the first place and how frosty the reception can be. Once the charges are laid, there's something called witness tainting that everybody's quite correctly very concerned about. You don't want one witness to be tainted with information coming from another witness. So what do you do with the complainant? Quite naturally, you keep her in the dark. So here's somebody traumatized by an event, facing an insensitive justice process that deliberately keeps her in the dark and says, oh, by the way, anything you say to any justice official, police officer, VWAP worker, Crown attorney, if it has any bearing on the case, it's going straight to the defense. There's really good reason for that, and that's necessary. My colleagues like Michael do a great job, deserve full disclosure. But what's the impact on the victim? There's no professional inside the system who says to her, I've got your back. No one. Except her lawyer. That's the service that I provide. I sit down with the complainant, and the first thing I say is, I am nobody's lawyer but yours. Everybody else you talk to is obliged to give what you say to the defense if it's relevant. My obligation is 180 degrees reversed. My obligation is to keep your confidence. And let's talk about somebody going through a traumatic process and what do they need. Laurie's slide was brilliant of, the baby reaching over to put an arm around somebody, metaphorically and professionally. That's what I do. And here's one line of an email I got from a client I represented 2 days ago. I can't tell you how anxiety and stress reducing it is to have a lawyer. I had no idea that would be the case. So the value that I provide, as lawyers, we often think clinically and dispassionately and technically about, objective services delivered, motions won, advice given. Let's start thinking about the soft skills that a good lawyer can provide. I'm there for you. This system will be frustrating. You don't control the outcome. It will be traumatic inevitably because it's appropriate to a certain extent that the defense challenge vigorously. You don't have anywhere to turn to unless you have a lawyer. And then you do. So I advocate for involvement of lawyers to ease victims through a process that's necessary but difficult. And in terms of particular points of representation, before the charge, before a victim makes a decision to come forward, it's important, as we saw in the videos. After a charge is laid, in anticipation of the trial process, to some extent, where it's fair to do so during the trial process itself, and afterwards on appeal. So I say there are a really important suite of services the Counsel for Complainants can offer to make this process a little more humane, a little more fair, and a little less traumatic.
Thank you very much for helping us understand your important role. I'd like to now turn to Judge Corbett. Judge Corbett, what are the main challenges that the current evidentiary law pose from your perspective, meaning the perspective of the bench? And do you have any recommendations to address those challenges?
Thank you. First of all, I'd like to say I agree 100% with everything that my colleague here, David Butt, said. The hardest thing being a trial judge, or one of the hardest things for me, was enduring the cross-examination of complainants, adult or child. And you think that a judge would have every control over limiting what defense counsel can ask, and they can be bullying and intrusive, and judges are constrained by the reality that the Supreme Court of Canada has described cross-examination as the ultimate means of demonstrating truth. So as a trial judge, when even things are becoming too laborious, or counsel is bullying, or counsel is saying, just answer the question yes or no, I think back now and I say to myself, well, why does she have to answer yes or no? Why not let the witness answer in their own way? But judges are so attuned to allowing extensive cross-examination that it can be very difficult to draw the line. And so, generally speaking, judges are very loath to interrupt cross-examination. And cross-examination can be demeaning, bullying, intrusive, grotesque, brutal. And that was when I was a judge. And I read cases today, and it is still going on. I was thinking of the case of the Crown versus SB, which is on appeal from the Newfoundland Court of Appeal, in which the Newfoundland Court of Appeal majority described the cross-examination of the witness as gratuitous humiliation and denigration. In that case, the complainant had told the police that she hadn't been unfaithful to her husband. In fact, she did have an affair, and at the trial, it came up, and the evidence was adduced of all the text messages between her and her lover at the time. It is excruciating to read, and it should never have occurred, as the judge pointed out. And there are other instances in that case where the witness was subjected to horrific cross-examination, and I urge you to read the decision. One thing that can alleviate extensive cross-examination is the use of admissions. And greater use of admissions have to be made. For example, in the case of SB, there could be an admission. Yes, I lied to the police about having an affair. I did have an affair, and I was nervous about revealing it to the police. And that could be the end of it. Oh, but that's not good enough for some defense counsel. They want to make mincemeat out of it. And it can be horrible. Another change, aside from encouraging admissions instead of prolonged cross-examination, it's time to reconsider the rule against allowing in prior consistent statements. Prior consistent statements are considered self-serving or oath-helping. So what happens when the witness takes the stand and is cross-examined? The witness is cross-examined on every inconsistency and every statement the complainant may have made to anybody ever, whether it's, well, you said you were wearing a shorty nightie today, and yesterday you said it was a teddy, or whatever. It goes on and on and on, and the judge, yes, can say, isn't that enough, so-and-so, but they go on. Then they go to the next minutia. So to counterbalance that, I believe that statements that are consistent should be permitted to be adduced by the Crown where the person to whom the statement was made is able to give evidence. It's particularly critical in child cases or in cases of vulnerable complainants. The child may be giving evidence years later because the assault may have taken place earlier, and yet you can't get in the statement that she made to her mother or her aunt or the teacher or the social worker unless they say, the defense says, that was recently made up, a recent fabrication. I think that rule has to be re-examined. And it's not a change that can come in the courtroom by lawyers saying, I object. They can't object. It's the law. It has to come from the people in this room. It has to come through changes in legislation. And the rule is a very old one. It's probably it came about, no doubt, when trials were conducted relatively quickly, so that you didn't want statements going in of what the witness, the complainant told her friends or her colleagues or whatever, because it was self-serving and oath-helping. In other words, you're making it more consistent. And but today, when you can have up to 30 months to have a Superior Court trial, some of these statements may be very important, and it is, no doubt on an evidentiary basis, a radical rule change. But if inconsistency is the mark of untruth, I believe consistency should be the mark of truth. I have one other thing I'd like to say, and that is that there was some reference that judges should always give written reasons in sexual assault cases. That's an undue burden and unnecessary. But what can occur is that in any sexual assault trial, the reasons for judgment can be transcribed. They can just be put on a website. That way, there is greater access to justice. We know what it is. It isn't what the courts are doing, and it isn't just happenstance that a reporter happens to be there and is witness to some horrific set of circumstances. And, oh, well, all right. I could go on, but...
Thank you so much, Judge Corbett, for those reflections. Now, I'm aware that we don't have a lot of time and that likely there are questions from the audience, but while people go up to the mics to ask their questions, I might just address one issue that I think is quite burning these days, given the prevalence of social media in our society. So could I ask panelists to comment on your views of the role of social media in sexual assault cases? In particular, in your view, does the law currently respond to the evidentiary and privacy issues posed by social media? Is there anyone who would like to comment on that?
Sure, I can take a shot at that. From the perspective of somebody who represents complainants on third-party records applications, I have a particular perspective on the potential problems that we need to really think thoughtfully about. Lots of folks these days live huge chunks of their life online. And so when someone has suffered trauma, I want to first draw a distinction between private social media, so where you go into private chat rooms and so on to chat with your friends, versus what you post for the world on Facebook. If you post for the world, frankly, you live with it in a courtroom. That's my view. But when you do make an effort to have a private chat, very often in the case of a sexual assault survivor, what's going on there? It's a form of healing. It's a form of therapy. It's a form of connection to loved one that, again, we've heard Lori Haskell talk about, that is, in effect, a form of therapy. It's one of the best forms of therapy if you've got somebody who can put that arm around you. And so we need to ask ourselves, just because the subject matter of the assault allegation, sexual assault allegation, is discussed in that private chat room, does it necessarily mean that it's relevant and should be disclosed? I think we need to ask ourselves very seriously whether that's a form of therapy that deserves some degree of privacy protection.
Thank you. Jill?
Yeah, and I just wanted to add to this. I certainly think that, with the exception of Facebook posts, social media type of exchanges, text exchanges or other exchanges, even if it's cell records, those do attract a reasonable expectation of privacy. They certainly do, according to the Supreme Court, for the accused, contents of a cell phone. I think the argument can be made that they also apply to complainants. So if that's the case, it means that they fall under 278.1, the provisions of the code, which require an application to be brought by the defense in order to get those records before the court. And we know that the complainant, the victim, has standing in any third-party record application under 278, and we know that they can have access to counsel for any 278 application. But really, that access to counsel only kicks in once there is an application filed by the accused or by the defense. And it's only the defense that can file the application. The Crown isn't even permitted to actually ask for third-party records. And where I see that the law has fallen a bit short is that those records, because they have this expectation of privacy, can only be produced or can only be disclosed, even if the Crown has them, with a full and informed waiver by the complainant, by the victim. That can take place once an application is filed by the defense if they are seeking third-party records. But what if the Crown knows that there are some records out there, and sometimes there may be some very useful records that have an exchange between the victim and the accused, or the victim and some of her friends on the night of the incident. Perhaps those would be relevant and the Crown would be willing to agree that they're relevant, but in order to properly protect the victim's rights, she would need some form of independent legal advice. It need not be long. It might just be an hour or two. A lawyer who can review those records, who can talk to the victim about her rights, and who can waive her privacy rights. And that way those records can become part of the disclosure process early on in the prosecution. We don't need to wait for an application to be filed. That causes delay. Sometimes it's resource heavy for the court, but it's only at that point where our legislation actually says that a complainant is entitled to counsel. And in Ontario, and I don't know about other provinces, but probably similar, we have a program where counsel will be paid for by the state, either by legal aid or by a ministry protocol. So the victim will get counsel for those third-party record applications that will be paid for by the state. But again, it's not until that application is filed by the defense. And I think there is or should be some movement for that process to take place even earlier on, so that we can deal with those types of records, some of those types of records, in a more expeditious manner.
I just wanted to say that social media is becoming a huge investigatory tool, and we don't have much research at all. I'm a researcher, so that's the place that I focus on how social media is created, how it can be manipulated, how it's used in sexual violence cases. Is it appropriate? Is it inappropriate? Do judges understand the uses and limits of social media? This is a terrifically under-researched area, and an area that a lot of work needs to be done. I also just want to say, too, that I don't know that much about social media. I'm not an active social media user, so I asked my 25-year-old stepson this weekend to talk me through the ways in which his friends use social media. And I, in particular, asked him, I said, if you went to one of your female friends and asked if you could access her group chat, would she show you? And he said, oh yeah, absolutely, she would. So I actually don't know how much of a degree of privacy there is in these records. And I think that if you're counseling complainants in any way, you've got to really caution them about how they use social media, because I'm nervous about saying this, but I actually think that there's a really good possibility that courts are going to say there is no expectation of privacy in social media, and if it's shared in the way that my stepson said this weekend, he could get access to just about anything going back 4 or 5 years just by talking to his friends. They would open Facebook accounts, they would open Twitters, they would open WhatsApp, they would open group chat, they'd hand the stuff over. So it's really hard, maybe, to make the argument that there's an expectation of privacy in those materials when they're so shareable.
Maybe if I can just add a brief point. I think I agree with David. When we're looking at social media, I don't think we can let the novelty of the medium necessarily dictate what happens in court. Public posts on Facebook or Twitter or on other messaging systems are just a modern way of generating a statement, of saying something to a friend at a party, or posting a note, or writing an open letter. I think the difficulty is when we get into sort of third-party records applications for things that are private, private text messages and other private communications. But we already have a framework for dealing with that. That's the same sort of thing that we look at if there's a diary involved, or if there's therapeutic records or medical records. And I think the important thing to realize, and it can sometimes be discounted, is that the rules are pretty stringent for that. Like, not only does the complainant have counsel and there have to be an application, but it's not enough. It's not grounds for the defense to be successful in that application to show that the complainant discussed the event or made comments about the incident in question. There needs to be more than that. So when we're dealing with these applications and looking at sort of private messages where there's an expectation of privacy, we also have to recognize that during these applications and the formal application process, it's not enough to say that the complainant made a statement about the event. There needs to be more than that to demonstrate its relevance and how it could be used in court. And so to some extent, there's some protection already for that privacy interest.
Thank you. That was very comprehensive, and I'm sure the audience appreciated it. I'm not seeing anyone up at the mics. Maybe I could just ask a follow-up question, whether or not you view the rape shield provisions having any role in this context. Anybody has any comments on that?
I think they do. I mean, what we know in court is that you can't get access to the records. We talked about that. But also the questions need to conform to the appropriate questions, and the information needs to be used in an appropriate way. And so if the worry is that, defense counsel may look at a complainant's Twitter feed and point out every time that she said or he said something about sexuality or partying or drinking, I mean, that shouldn't be happening in court. And there should be mechanisms to control that. I think it does happen sometimes, but I think that's something that needs to be controlled, just as if those questions were asked about sort of less novel forms of communication.